مقطع اليوم قانوني. تكلمنا سابقا عن الهولدنج، اليوم مقطع اليوم يتكلم عن الدكتا. الدكتا هي عبارة عن الآراء التي تخرج من المحكمة، لكنها ليست من المنطوق الأساسي في الحكم، ولا تعتبر من الجزء الأساس الذي بني عليه في الفصل في الدعوة. هي عبارة عن آراء ممكن يستأنس بها ويسترشد بها في المستقبل، لذلك فهي ليست ملزمة قانونا ولا قضاء. يعني إذا شفت في دكتة في القضية فهي ليست ملزمة، لأنها آراء استرشادية ممكن يسترشد بها في المستقبل ويستأنس بها. تابعوا المقطع ومشاهدة ممتعة.
Dicta, plural of dictum, means statements or comments made by a judge that are not essential to the court's final decision. In plain English, it's the judge's extra commentary, interesting, influential, but not legally binding.
Let's hear the following dialogue to better understand the meaning of dicta.
Hi Jordan, quick Civ Pro check. What exactly is dicta again? I know it's not the holding, but I always mix it up.
Same here at first. So, dicta is short for the Latin phrase obiter dictum, which literally means something said in passing.
So it's like side comments from the judge?
Exactly. In law, dicta are comments, suggestions, or observations a judge makes in an opinion that aren't necessary to resolve the case. The case would come out the same even if those comments weren't there.
Got it. And because they're not necessary, they're not binding, right?
Right. Dicta are not legally binding on other courts. But, and this is important, they can still be persuasive authority, meaning future courts might cite them if they find the reasoning useful.
So judges can't ignore them completely.
Yep, especially when the dicta come from a respected court or judge. Even though it's technically extra, it can still influence how the law develops.
What about dissents? Are those dicta too?
Generally, yes. Dissenting opinions are usually considered obiter dicta because they don't represent the court's decision. They don't decide the case, but they often shape future arguments and opinions.
Interesting. So dicta can include hypotheticals too?
Absolutely. Dicta can cover hypothetical facts, imagine future cases, discussions of laws that aren't directly at issue, or even criticism of other opinions. That's part of why people argue about what counts as dicta.
Yeah, I've noticed professors don't always agree on what's dicta versus holding.
That's super common. Legal scholars often disagree about where the line is, because sometimes a judge's extra reasoning feels pretty central.
But even if it's unnecessary, it still gets studied?
Definitely. Dicta are frequently studied, cited, and even adopted later. Sometimes an idea starts as dicta and later becomes the foundation for an actual rule of law.
So the takeaway is, dicta isn't binding, but it's far from meaningless.
Exactly. Think of it as judicial commentary that doesn't decide the case, but can still shape the future of the law.
Okay, that finally makes sense. Dicta equals said in passing, not required, not binding, but still powerful.
Perfect exam answer.